15 minutes each. And unless you have any questions about the process to follow or exactly what it is that you're here to decide today, I'll be happy to explain that a little bit further and allow Chief Lynn's attorney to also explain it with equal time. Otherwise, we can get started. Would you like us to proceed? Okay.
Commissioners, due to the setup of the room, we have permission to set on directions. My apologies, it takes just a minute to come on. We'll be ready.
We did. We read that one down.
May I proceed? Well, let me say first, that the chief of police of any department holds a higher standard than any normal citizen. Because they are the ones trust, that we look up to, we depend on to enforce the laws. And now I'm gonna take you through kind of a timeline to tell you what happened in this particular case for the mayor to make the recommendation that he did. Back on May 17th, 2024, as you can see in this police tow log, on 410 East 7th Street, there was a tow notice placed on it. And he instructed Patrolman Hott to put that notice on the vehicle. The notice on the vehicle, and I'm sorry, may I interrupt 1 minute? They have to.
I'm gonna give you.
I'm gonna hand you the exhibits in case you cannot see this well enough. You can see like me, I can see it. And these exhibits may not be in order, but they will have somewhere on the page the exhibit number if you need to refer to them in the book. And read them, then you can follow with me. So Patrolman Hott was ordered by Chief Lynn to place a tow notice on this vehicle as an abandoned and junked vehicle. Now, I would like to show you the vehicle and where it was parked. This is the 2007 Dodge that we're referring to. It appears to have fine tires on it. Appears to be in good working order. And I'd like next to show you the title of that vehicle. It was purchased in 9/18 of 19. Ms. Saunders passed away in late 20, approximately 2 years later. Donna Chestnut is the homeowner of this home where the vehicle was parked with her permission. When the vehicle was purchased, the sale price at $16,250, along with approximately another $1,000 in taxes. So a $17,000 vehicle was purchased and only able to be used by Ms. Saunders for approximately 2 years. Ms. Saunders was not Ms. Chestnut's mother, although she did have several heirs. She had 4 sisters, You wanna see that? Okay. Now, after the tow notice was put on, it was put on for an abandoned and junk vehicle. Then, on June the 21st, Chief Glenn went to Donna Chestnut in the morning and said, I have prepared this letter and I want you to sign it. And I want you to admit that this is an abandoned and junk vehicle, which it was not, and that you are in violation, which it was not. A threat, a bond. This 2007 Dodge Ram truck, red in color, has been left on my property. Oh, it was on her property with no permission. The vehicle belongs to my stepmother, Diana Sanders, that passed away several years ago, which is in 20. So they knew that Diana Sanders, he knew Diana Sanders was no longer alive. Now one would ask, why would such a letter be presented? It had never been done with the police force before. It's not a form letter, and it's nothing they ever used. And I'm gonna show you. Shortly after the letter is signed, Time Mark Road Service shows up at 12:22. Takes the tow for tow, or takes the car for tow, and writes on the ticket. And I want you to pay attention to this, if you will, because it's a little hard to read. Don't junk Glenn wants to buy for junk parts. June 21st at 12:22. Now, the reason the mayor got involved was because Chief Glenn did come to him and say there is a search warrant for my property. And it's due to a felony. Code 61-324D, fraudulent schemes. Any person who willfully deprives another of any money, goods, property, or services by means of fraudulent pretenses, representations, or promises shall be guilty of the larceny thereof. Now, in order for a police officer to be terminated, they do not have to commit a felony, nor do they have to commit a misdemeanor. But there has to be cause. So with this affidavit and search warrant, which is extensive and is in your exhibits, it has a long dissertation of what happened, according to these investigators. This is a photo of that beautiful truck. Two thousand 2007 Dodge Ram. On the premises of either the chief or his mother's. You look at the next page, or you follow me on the screen, you will see that this is where parts are taken off the tires. You look at the next page, it appears that these tires may be on this vehicle. and those disregarded. Flat tires. No flat tires. And if you look at this, the vehicle that the chief owned now has parts on it from the 2007 truck. This being presented to the mayor. He then put the chief on paid administrative leave. And on March 27th, 2025, he was directed to appear before Real Town Hall on April the 7th at 9 o'clock for an interview as part of the investigation for the town of Bell. And I'm sorry, Commissioners, that's Exhibit 14. Now, if you look at my Exhibit 15, this is where he was given his guarantee rights. And he'll tell you that he was given them and signed them. The next document I have up here for you is his statement of rights that were also read to him, of which he signed. Now this is where the case gets rather interesting. Tamar went out and hired, or cheap land, J&M Title Service to do the title work. If you'll notice, the date of service is June 28th. They have to give them 10 days to respond. The owner's name is Diana Saunders. Diana Saunders is deceased. I mean, really. The address on here is not the address that is on her title, which is a requirement if you use the title. The address on the title is P.O. Box 1061. This is not the Sanders address. They claim that the vehicle was at Tamar 15095 McCorkle Avenue. The vehicle was not there and was not towed there. They also said where it was taken into possession and custody. Doesn't say Bell. It says Cedar Grove, West Virginia. So by this simple notice, it would be very difficult for anyone that knew that car was parked in Bell, that this may be the same vehicle. But worse than that, the return receipt was signed by Danny Sanders. Danny Sanders is not an heir. As I earlier showed you, she had 3 sisters, but this was her son-in-law. And it was served on July the 2nd. And as required by law, they had to give 10 days notice. 10 days notice would be July 12th. This commissioners is where the vehicle was allegedly parked. It's Exhibit 9. At Tamarack's large storage facility where he keeps most of his vehicles. However, it was actually parked and kept at 3101 Maple Street. And right here is Rick Howell's home. Rick Howell owns Time Warner. Now, when the mayor was questioning Chief Glenn about how he came to have the vehicle, he said, well, what I would do every day is make a bank deposit. So I would go from Liberty gas station all the way, and the bank's up here. As you can see, Glasgow Bank. And I could see the vehicle parked at Rick Howell's back lot where he parks his tow truck. If you look at this map, when you pass the Liberty gas station, you have to turn down the street, go down another street, and go down another street to even see that vehicle. Now I would like to focus your attention a little bit on what an abandoned motor vehicle is under West Virginia Code 172401, which is your Exhibit 5. And an abandoned motor vehicle is one which has remained on private property without consent of the owner or person in control of the property. So this certainly was not an abandoned property. Now, if you turn the page and go to number 11, definition of a junked motor vehicle is discarded, wrecked, ruined, scrapped, or dismantled. I submit to you that this $18,000 vehicle was not scrapped, wrecked, ruined, or dismantled. Therefore, it was neither a junked or abandoned motor vehicle. Now, in order to take possession of a vehicle and sell it or to do something with it, you need to obtain a title. And that's why it is important for the enforcement agency, which was the police department, to give notice to others that it had been taken into custody, and the notification has to be by registered and certified mail. It has to have the identity of the last registered owner of the abandoned vehicle and has to contain the address. Now, it goes further to state for which a registered owner cannot be ascertained by due diligence or investigation. that's when you're required to give 30 days notice. And the towing company, registered with the Public Service Commission, must obtain a motor vehicle for certificate of title and registration for the abandoned motor vehicle or junk motor vehicle. And then upon payment, the towing company may sell the vehicle for private sale or public auction. Now, let me tell you what has to happen to an abandoned motor vehicle or junk motor vehicle under the law. The enforcement agency may take into custody and possession from private property. The enforcement agency shall, which means it's a requirement, to give the private property owner and the owner of the motor vehicle a 30-day notice by registered or certified mail that the action will be taken unless the motor vehicle is restored for functional use. So because there was permission to have this vehicle on her property, she was to be sent a certified letter that said, you have 30 days, even if it was junked or abandoned, which it was not. But the 30 days would have given her time to take this $18,000 vehicle and maybe find the heir to it. Because no one knew. None of the heirs knew. West Virginia Code 1724A6. Even if Chief Flynn did everything right and could have sold or used parts from that vehicle, what he was required to do was to pay all the cost to get the title and then to put the certified letters out, and then any money, the remainder of the proceeds of the sale shall be deposited in the state road fund. Because police officers are held to a high standard. You'll see in this case where he received $500 for selling parts out of that truck. And then he took other parts of the truck and put him on his vehicle to increase its value. And then he agreed with the towing company to pay them $300. But he didn't pay $300. And the towing company never sold him the vehicle. It was a gift. An illegal gift. For him to receive a financial gain. And to harm the innocent people that knew nothing about the car being repossessed. So on July 7th, July 9th, I'm sorry, July 9th of 2024, and if I take you back to the notice, which you will recall until July 12th for the owners or anybody to reclaim it. Well, he doesn't even wait till that day. He goes to J&M Title and starts getting the paperwork ready and claims that it's an abandoned vehicle, and the authorized agency to request a plate for the above listed vehicle was Dell, the Trojan Hawk. July 9th, 24. Well, I submit to you that Officer Hott did not sign this, nor would he. He disagreed with putting the tow notice on the car, but felt he had to do it, because under civil service, you can't ignore a demand from your supervisor. So he put the notice on and took the position, he wasn't gonna tell her. He didn't wanna have anything to do with it. And he certainly wouldn't sign this. On July 9th, again before the notices are even up, this is affidavit of possession of a junk motor vehicle, a required paper to be signed, turning the registered owner, who is deceased, over to Robert H. Glenn. Name of applicant or title. July 9th, 2024. Who signs it? Who's applying for a title to this vehicle so that Robert Glenn can have it put in his name? It's the Bell Police Department, the Trojan Hawk, 222. See, look at these. Officer Hott's gonna say that's not my signature. Officer Hott's gonna say, I didn't make that. I'm not real sure what Officer Glenn is gonna say as to why these two numbers look almost exactly alike. I'm not sure, but give me 1 minute, I'll finish up. Here's the bill of sale, which this sale was for $300. The buyer certificate was to be, again, Robert Glenn. These did not get turned in to the Department of Motor Vehicles because the money to pay for the titles was $175. And Officer Glenn took the position, I don't need one. They called the title service company and said, we don't need a title, we're gonna jump it. And lastly, I just wanna say an officer's held to a higher standard under West Virginia Code 62.5. Where a public official may not knowingly uses office for private gain, he may not accept gifts of any kind in the town of Bell, or held to a higher standard of conduct for police personnel, or higher than the standards applied to the children. Excuse me for going over, I never read what it was, but thank you.
Good morning, gentlemen. If you look back at what's been gone over so far and start from the beginning, on May the 17th, I think it's there, Exhibit 2, we've got it as Exhibit 1 here, but it's the police code law. You'll see that under the initials there, that is signed by Hot. Now, it's our understanding that the evidence in this case will show that that is who placed the tow notice on the vehicle. It wasn't Glenn, it was Hot. And that it says off to the right there, Glenn towed 6/19/24. When in fact, the tow notice, from Timark shows that it was not towed on the 19th, it was towed on the 21st. Now, one of the exhibits that was gone over and discussed a little bit was investigation for a search warrant where a certain CI is referred to. And it's not covered up very well, but that CI is currently a police officer with the Bell PD, has been since 17. All right, that CI is Officer Hop. Okay, the one that put the tow notice on this vehicle. I anticipate the evidence in this case is going to be that prior to any of this, there's a long-running standoff between Chief Glenn and Hop regarding things such as who's going to get the new cruiser, who's going to get to work weekends or not work weekends, who's going to get promoted to sergeant. And all of these things between Chief Glenn and Officer Hop led up to this investigation that in the report, the CI is Officer Hop, who gets all this together, who puts the notice on the vehicle to have it towed, and then goes to the what is it, LET, the Law Enforcement Training Board, with this complaint. And they said, well, we don't do investigations. Take it to the CSI, the State Investigative Place. So he's out here shopping around this set of facts that he thinks finally shows Glenn has done something he can get him on, to see if he can get to today, to get Glenn fired. Now, Glenn's been, I think, about 15 years an officer here in Bell with a clean record. I think there's even a write-up in his file. So you're gonna see that history between Hop and Glenn leading up to this. Now, there's no question that Hop put the tow notice on there. Now, our evidence will be that the mayor's the one that noticed this vehicle in the first place and asked about it being towed. Now, you've heard a lot about the West Virginia Code. Interestingly, you haven't heard much about the town of Bell and their ordinance, specifically 361.07, which lists the abandoned and junk vehicle definition that the town of Bell is operating under to carry out the tows. And if you look back at Exhibit 1, this lists vehicles in the town that first date, there's 2/3/23 through 8/24/24 is this list. So it's not irregular, you can see, for the town of Bell to put a tow sticker on a car. Now, over there to the right of Exhibit 1, you'll see where it says fixed, moved, one of them's towed there. But the evidence will be that Chief Glenn offered Miss Chestnut the opportunity. Can you move this vehicle out of the town of Bell? Can you do anything with it? Can you put it in your garage? Any of these things will allow you to satisfy the ordinance, and we won't have to tow it. That happened a lot where a vehicle was fixed or was moved to a different location. Now, this vehicle clearly hadn't moved for 4 years. since the lady parked it there. She died in 20, I think it was, and this was 24. And there's no evidence that it had moved in 4 years. Time mark towing, back to exhibit 2, it says what time they got there and what time they left. He will testify, it's exhibit 4, I'm sorry, I don't know what their numbers are, but, I think he was there for over an hour trying to get this vehicle loaded because it wouldn't start, the tires were flat, it wouldn't move, and they had time getting it loaded. Now, I think a big misunderstanding here and a big point of evidence will be, this tow notice from Timark is dated 6/21/24. That's the day that the vehicle was towed. Now down on the bottom of that, it says don't jump Glenn to buy for junk parts. Glenn wants to buy for junk parts on the bottom 2 lines of that. Now, I anticipate that you're gonna hear evidence from Rick Howe testimony that that bottom part there was not on this on 6/21. That later, Glenn called him and said, hey, did they ever come and get that truck? If they don't, I'll buy it for parts. And that he then later, weeks later, put that on this notice so that it wouldn't be junk. That was not there on the 21st when the vehicle was towed. Now, there's some question about the vehicle being parked at Rick Howe's personal residence. Vehicle was located in a field up here. It was not at Rick Howe's residence, and I think that will also be met out by the evidence here. The vehicle once taken was not Glenn's. It was in Timark Towing's possession. Timark Towing sent out the notice to the address that, now you'll notice that the P.O. box was the address on the title. I believe the P.O. box and this Jordan Creek, they're both Elkview addresses at the same place. This is where the notice was sent, and the return date is 7/10/24. It was signed by Danny Saunders on 7/2, which means that that's when he received it. This is the little green copy of the little green card that you get when you have a certified letter. And it's signed on 7/2. Thereby, the 10-day notice would be July the 12th. That Timark, not Glenn, Timark would have gained title to the car or had a right to get title to the car, or the truck. So that notice was done. It was sent out by Timark. It was signed for at the address by Danny Saunders. As counsel has indicated, Mrs. Saunders was deceased at this time. And thereafter, the vehicle was Timark's. Now, Glenn, with the title folks, Timark contacted them, the title service company, and was told, if you're gonna use it for parts and junk it, you don't need to get a title. Timark will, Rick Howe from Timark will testify to that. So they didn't get a title because it was gonna be used for parts. Now, the pictures and all that, yes, he bought it from, or had a deal with Timark to buy the truck from them later if the folks didn't reclaim it, as they're entitled to by law to reclaim it. If they don't come and reclaim it, then Timark's got it to do with what they want. You're gonna hear Rick Howe say he was gonna junk it. That this vehicle did not start, the whole 18, she might have bought it for 18,000, but it wasn't worth 18,000 at the time that it was taken, and at the time that it was to be junked. It wouldn't start, tires were bad, engine wouldn't turn over. I think there will be some testimony that there was, liquid of some sort leaking out of it when they pulled it to tow, which is also part of the town of Bell ordinance definition of junk vehicle. So the evidence in this case is going to be that there's not some scheme by Glenn to defraud this woman out of her truck. To the contrary, there's an ongoing interdepartmental feud with the officer and the chief, because the officer wants promotions and wants the new cruiser and wants Glenn to do things for him that he can't do. He doesn't have the authority to give him a promotion. He can't do that. But you'll see from this investigation who is the one, the CI, confidential informant, going out and starting all this and drumming this up. If the people would have redeemed, come and gotten the car, or if Rick Howe from Time Mark had junked it, Glenn would he would never have been involved with this. If the car was going to be junked anyway, he had the same truck. He didn't buy that truck or have a similar model planning to get this one. He had that truck. If this was going to be junked anyway, hey, I'll buy it. I can use some parts off of it. There's no fraudulent scheme. There's nothing that's not above board here. And the whole process was begun by Officer Hawk putting the tow sticker on the vehicle. And the mayor beginning a requesting initially that the vehicle be towed. So there's no fraudulent scheme. There's a regular process that the city of Bell uses to tow vehicles. That was followed. Now this letter, which Ms. Chestnut signed, granting authorization for her vehicle to be towed, was used because there was a previous incident with a vehicle on a church lot that was towed, and there was some discussion about that and whether that should have been done or not. So the city decided to start using this form to have it signed by the person whose vehicle was being towed or who had possession of the vehicle. That's why this was used in this case, following procedure that was in place, not trying to run some scheme on a lady in her stepmother's truck. And that's what the evidence is going to be here from people that are going to testify. And that there's nothing underhanded going on here, that Tom Mark and Rick Howe were involved in the situation from the day of the tow to the day that Glenn came and got the vehicle with his permission. So we think that Officer Glenn's 15 years of service to the town of Bell with no blemishes on his record, and clearly an interdepartmental squabble between patrolman and chief over a power struggle will show you that this is not anything that would result in you upholding the recommendation of a termination. I think you have the authority to, as lesser included penalties, to put a letter in the file or do a 2-3 day suspension or some other alternatives that are available to you other than terminating a 15-year service career to the town of Bell. Thank you.
Short response. I will show you the city ordinances. Chapter, Article 361. The definition of abandoned vehicle is no different. Which has to remain on private property without consent of the owner. They had consent. They had consent. And as far as the junk motor vehicle, non-operational, no parts were missing. Leaking fluids. Well, there's only gonna be one person or two people to testify that there was leaking fluids, if there was. But that vehicle was not junked, it was non-operational. It was operational, and you can have your car sitting in your driveway and it might be leaking fluid, as all our cars do. Second issue was 7 months after the vehicle was repossessed, both vehicles. It was never, he never paid for the vehicle, and he never took the $500 he received for parts and turned it over to the Department of Highways. The police, because of the search warrant, now have both vehicles. Thank you.
We can take a short break, or I can call our first witness, it's up to you, Commissioner.
Did they agree to a 15-minute? That's where they're going, they're getting the pen.